All right, welcome back. On the Record continues. We're continuing our conversation around the new provisions in the labour law, which appear to require the secret ballot of workers in the workplace before a strike can be called. Zwelinzima Mavavi is the General Secretary of the Trade Union Affiliation of Federation SAFTU, and of course, Gerhard Papenfuss is the CEO of the National Employers Association. Gerhard, I want to step away from the letter of the law. I'm not a lawyer. I don't know if you are. I think, Mr. Mavavi, that you're not a lawyer as well. But I want to focus on the principle. Again, why is it the business of the employers how a union decides when it's going to go on strike?
Before I answer that, I just want to say that I think I'm disappointed in this, that the employers do not have so much power in this thing to utilize the absence of a strict application of the law to stop a strike in the court.
I realize your disappointment. Please answer my question. Why is it your business?
If a strike is conducted for the purposes of withholding labor, we understand that's the power that workers have. What is happening in our labor dispensation is that workers are forced to participate. There's no freedom in this. There's no democracy in this dispensation. Workers are dragged out of the workplaces. If you don't participate, your house is burned down. And this is a general statement. Doesn't happen every time. Your house is burned down. Your life is threatened. Strikes have become extremely violent. It's a battleground. If you will come with me and I show you that employers have to set up war rooms to see what's going on, to protect properties, to see where strikers are going to, and people's lives is at stake here. So what we say is it should have been made our business even more. The state has intervened here belatedly and a bit reluctantly and a bit hesitantly, but at least there's something now. So we want to stop. We want a democratic thing that if all the workers say we want to go out, well, then it's so. We say, and that is our view, the majority of workers is not in favor, and if you have a secret ballot, you might just find that strikes won't go ahead.
Okay, 2 points. Firstly, isn't there already a democratic safeguard because union leaders are elected? Right? You can't have a strike without workers supporting it. It doesn't make sense. Workers have to support it.
Oh, I don't think so. I think, you know, to stand up in the dynamics of a trade union meeting in a hall where people is heated up and say we're going to strike, for a worker to stand up at the back of the wall and to shout, no, we're not going to do that, we mustn't do it. It's just not happening. The dynamics of the moment dictates that it's not going to happen, and that's why the secret ballot. This is the safeguard that's being built in.
Okay, and the second point is, we have time and time again, the Labour Court will rule that a strike is unprotected, right?
Yeah.
It doesn't stop the strike. It doesn't do anything. So isn't this yet another piece of legislation that is not enforced and doesn't actually change the nature of our strikes at all?
You know, if a strike is unprotected, and we're not going to go into the legalities on what the impact of this is, but if a strike is unprotected, of course you can sue for damages. And employers are reluctant to do it. You know, once the strike is over, people say, let's go to work and let's go on with our lives. But I think that must stop now. I think employers must really go to court and sue.
Okay, but you didn't answer my question. I mean, introducing a strike ballot isn't going to stop strikes. Because even if they don't do it and the strike's unprotected and the Labour Court rules it's unprotected, it doesn't matter.
Well, that brings me back to my point in the first place, that I think there's shortcomings in this legislation. I would have liked the thing to be much more strict, to give the employer the power to say, we insist to see what's happened in that strike, ballot, is it properly done, so that we can go to court. I don't think we have that power. And it will be left to the union to do it the way they want to, even if they will do it at all. And there's not much we can do about it, and I think that's a shortcoming in the Act.
No. Mr. Mavavi, isn't it true that there have been instances where some union leaders, particularly when it comes to money, have abused the financial power that they have over a union? There are various examples we could go into. Some of them have come very close to being deregistered as a result, but in some cases, millions of rand have gone missing. This suggests that we can't trust every union leader, even if they are elected. So back to my original point, doesn't having a strike ballot then make sure that the union leaders, it keeps them more honest?
There's a separate regime as to what the department must do every time the trade union movement leaders steal from the workers and betray their trust. The issue of the strike and the secret ballot is an absolutely separate matter to that. The workers themselves must at all times make sure that they develop their own confidence, politically and organizationally, to tackle the leaders who abuse their power in that fashion. So we shouldn't mix that. The second part, as we speak, 2 strikes have been interdicted. Not in future, now. Workers in Fosco have been stopped from going on a strike because the judge says NUMSA's constitution doesn't have a provision for a secret ballot. In another company, same judgment, and that's why NUMSA is appealing. And we hope that it is going to take that into the Constitutional Court. So the third issue that I think that Gerald is missing, even if there was a 50% +1 of workers voting in support of a strike, there will be some others who do not want to go on a strike. There is absolutely nothing in the legislation that can stop intimidation. Intimidation gets stopped by the police action. It is wrong, and we don't encourage it. We always condemn it every time it happens, but that's a function of the state to protect the right of workers who do not wish to participate in a protected strike or even in an unprotected strike. The legislation is not going to help that in any way. So for that, I must emphasize that. So we mustn't cloud issues in order to justify a salvage attack on the rights of workers in this country, an attempt by a bourgeoisie state, a capitalist state, which have been employed and captured by the capitalist class to tie workers into an arrangement where their last weapon will be taken away through a bureaucratic maneuver, as it has happened through the amendment of this legislation. Right. Now, Gerald says he wished that he could have more, so that I'm sure he will want to sit in the meetings and hire agent provocateurs to go to court and sponsor them to go and challenge whether the secret ballot was conducted fairly and whether there were technical problems here and there, which is our nightmare and our biggest fear going forward, is that they will find people to sponsor, to go to court. In fact, in terms of the law, contrary to what they are saying, they will be allowed to challenge the results of the secret ballot on the basis of allegations that could be manufactured. 10 people can come forward, will give you 7,000 rands more, make up an affidavit that I was intimidated to vote yes in that secret ballot. So the system is open to an abuse because the government is trying to interfere with the internal arrangement of an organization that have been formed by other people that are independent from the government. This is an attack on the freedom of association. That's why we are not only aiming to take it to the Constitutional Court, but we will take it to the ILO and say this government is undermining its own signature in terms of the Convention 87 that talks to the issue of freedom of association. But more importantly, Stephen, we are not going to turn into the other side and get more clapped. We are going to the streets and we are calling on our members to prepare for a total occupation of South Africa in all of the cities until this government agrees to withdraw all of this insult and assault on the right of workers to strike.
Okay, I mean, I'm going to come back to that in a moment, but I do want to just ask you, Gerard. I mean, in a situation like this, are you going to be a party in the court case? Or are you going to argue in the Constitutional Court on this?
I think that this piece of legislation is so meaningless that we won't, because it doesn't give employers enough. We're actually not a role player in this thing. You know, Mr. Vavi and I are looking at the same thing from a different angle. The influence that capital has on government, from my point of view, is so limited. You know, that's our frustration. We beg to be heard. our view is that the appropriate ministers really listen to them, but not to us. But we're looking to the Table Mountain from two sides.
Well, they used to. It gets a bit complicated.
Yeah. But yes, the thing is exactly the two. He says that in two cases the Labour Court interdicted the strike. That might be so. I'm only aware of one, but what happened in that one case is exactly that. The court said, since you don't have that in your constitution, I cannot protect you. We say if NUMSA had it in its constitution, they would have had the protection that the court would have granted them. So this thing doesn't help us. And I think, what I agree with Mr. Varvie, I understand that to comply with all the technicalities of the ballot might be a nightmare, but it's not for us, to employers, to even utilize the court to say there were shortcomings. We're out of the game. It might be somebody amongst their own ranks that might do that, but not us. So I think there are severe shortcomings. I think this is a lame piece of legislation that means nothing to us. Scare them a bit, and we say, we sit here, look at it, and we say, we don't know what you're scared of. Maybe perhaps concerned about your own membership. But if this is a piece of legislation, if they go to court, we'll sit back and say, what must happen, must happen.
I didn't expect you both to be opposed to the legislation. Right. Gentlemen, thank you very much indeed. Zwelinzima Varvie, the General Secretary of the South African Federation of Trade Unions, and Gerhard Papenfuss, the CEO of the National Employers Association of South Africa. That's on the record.